On Monday, April 1st, 1940, Attorney General Jackson gave the following speech to the United States attorneys, who then were serving in each federal judicial district across the country. In the speech, Jackson, who had been Attorney General for only 3 months, offered his views on what constituted proper ethical conduct for federal prosecutors. He said, among other things, it would probably be within the range of that exaggeration permitted in Washington to say that assembled in this room is one of the most powerful peacetime forces known to our country. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. The prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard. Or he may go on with a public trial. If he obtains a conviction, the prosecutor can still make recommendations as to sentence, as to whether the prisoner should get probation or a suspended sentence, or after he is put away, as to whether he is a fit subject for parole. While the prosecutor, at his best, is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst. This particular letter and speech to federal prosecutors is one which I know is oft quoted. How do you react to this kind of letter that was given 70 years ago?
I'll tell you, that just shows the wisdom and the knowledge of, at that time, Attorney General Jackson, because you do realize that the amount of power you have as a United States attorney is formidable. And you have to be aware that any time we do something in public, it is going to affect somebody's life, their family, for eternity. And I know, speaking for myself and the Assistant United States Attorneys in our office, we go over investigations any number of times before we're satisfied there's enough evidence to charge. Sometimes there's I would almost say a disappointment that you see in the papers that somebody a public figure who's been accused by rumor or otherwise to have committed a crime, why isn't that person been charged yet? What is taking so long in the investigation phase? And that is, I think, because our office, federal prosecutors, we take statements such as that very seriously. And we don't bring a case. We don't even ask a grand jury to indict a case, frankly, unless we think we have evidence beyond a reasonable doubt to convict. The standard to charge is probable cause, just a little bit more likely he committed the crime than not. That's what it takes to indict. We don't bring a case, and we don't ask to indict. We don't ask the grand jury to charge unless it's evidence beyond a reasonable doubt. And that's one of the ways that we try to guard against the danger and frankly, the improper use of some of the force and some of the authorities we get. The other thing we try to do, frankly, is have accountability. And how do we do that? All of our charging decisions by assisting United States attorneys, first of all, begin with an investigation by a federal law enforcement agency. And even if it's a local crime, and there's no doubt that we help our local partners with crime, we do that all the time as part of a way to identify all perpetrators, not just the ones who may be located here. Every federal agency has its own procedures for opening cases. They just can't open a case because the United States attorney thinks that they would like to harass somebody. Their standards, predication. Then those agents are all sworn law enforcement officers, many of them highly educated men and women who are doing federal law enforcement as a career. They've all taken oaths similar to ours to defend and uphold the Constitution. So a case likely wouldn't even get to our doorstep until it's met this screening process, if you will, by the agency. Even once it's in our house, though, the prosecutor has to write down in a document exactly what the evidence is supporting each charge. And that forces the prosecutor to think through the elements of a crime, make sure there's sufficient evidence, and then to convince two levels of supervisors that his view of the evidence, his view of the facts is accurate, and in fact a violation of law occurred. So it's the accountability, it's the way we divide power in the criminal justice system between prosecutors and investigators. And frankly, one of the most important pieces too is the defense bar. The criminal defense bar in Western New York is exceptional. And they keep us on our toes as well. And if there was any kind of foul play or allegations of misconduct, they bring it to the independent judiciary. And the judges, of course, as you would know, serve life terms. And all of those checks and balances that frankly go back to our founding fathers are in use. And I think they guard against some of those sentiments that Justice Jackson was addressing when he gave that speech. But fortunately, that speech lives on. And it is important for us to hear it time and time again in order to realize that we do have this sort of power and we can't misuse it. Because once we do, if the public's respect for what our office does ever declines, then that'll be the beginning of the end, I think, because we all as American citizens trust our law enforcement officers. We should. There's the occasional rogue officer and we prosecute them. And that's rare. It's even more rare to have a rogue prosecutor. But when that happens, we discipline that prosecutor or disbar him. But nevertheless, it has to remain the rare case, and we keep it rare by remembering and commenting and thinking about those very wise thoughts.
Notre Dame, University of Buffalo Law School, criminal law. What's the connect there?
Growing up in the 60s in modest circumstances, it was pretty clear that the highest status people in the town of Cheektowaga, where I was born and raised, and as well as the east side of Buffalo, was the lawyers. I had a lawyer, Mr. Miller, that lived on our street, actually, and that combined with a book I read about Daniel Webster, where in this fictitious story, Daniel Webster argued against the devil. Maybe some of you know the Stephen Vincent Benet story. Inspired me to think that I would want a career as a trial lawyer.
You've had some high-profile cases. Talk about, for those who, it was flashback for me, but your case with Donald Sly Green. A little background and kind of a little bit about that. Donald
Green was a man who had already been convicted of murder and was spending what should have been the rest of his life in the Attica prison. And then he was later shifted to a downstate prison facility, which was even more secure, known as Shawangunk. And even though he was in this prison facility, he was continuing to run a drug organization using the prison telephones. Having done street gangs in Washington, prosecuted, when I say done, it means I prosecuted them, including murder cases. So I kind of married the experience of prosecuting killers with the civil RICO law, used the criminal aspects, and we charged 36 men and women under this RICO statute. And we convicted everybody but one. That one person was actually under indictment when he was killed by one of the other gang members that was concerned about him. So I consider that a success because everybody was convicted. The qualities of a good prosecutor, as defined by Robert Jackson in 1940, are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyways. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor, who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. As for one, Robert Jackson has just defined U.S. Attorney Bill Hochul. And I thank you very much for coming. Thank you.